R.V. Miller, often referred to as the arson squatter case. It is the definitive authority on criminal liability for an omission to act, specifically through the principle of a continuing act. The defendant being James Miller, a vagrant squatter in Birmingham. Hello and welcome to Landmark Case Laws Simplified. Buckle up as we explore the fascinating world of Republic v. Miller together. Miller fell asleep while smoking a cigarette and accidentally set fire to the mattress he was sleeping on. Upon waking to find the mattress smoldering, he did nothing to put out the fire. Instead, he simply moved to another room, allowing the fire to spread and cause extensive damage, costing £800. The legal issue was whether Miller could be liable for arson when his actus reus, the guilty act, was accidental and his subsequent mens rea, the guilty mind, arose only after the accident, at a time when he was merely omitting to act. The House of Lords established the principle of a supervening fault, or a continuing act. The court held that the actus reus is not just the initial act of setting the fire, but the entire sequence of events. Once Miller created a dangerous situation, the fire, he came under a duty to take reasonable steps to prevent the harm he had started. Lord Diplock articulated the principle as follows. I see no rational ground for excluding from conduct capable of giving rise to criminal liability, conduct which consists of failing to take measures that lie within one's power to counteract a danger that one has oneself created. Therefore, when Miller woke up and realized the danger, his failure to act, omission, combined with his recklessness, the mens rea he formed at that moment, made him guilty of arson. This case is a cornerstone of criminal law because it clarifies that an omission can constitute the actus reus of a crime if the defendant created the danger. It bridges the gap between accidental actions and subsequent criminal intent. Thanks for watching and being part of our journey. Your support makes all the difference.